Assalamualaikum warahmatullahi wabarakatuh, and a very good day to our lecturer, Ms. Hajar. In this video, we are going to present about the Industrial Relation Court case, which is the case between Abdul Malik bin Jaafar and Kelab Rekreasi Tentera Udara. Before we start, let me introduce ourselves first. My name is Nursyazwana binti Suhaimi.
My name is Nursyazwani binti Suhaimi.
My name is Nurul Ainna binti Yusof.
In Malaysia, IR is governed by the Industrial Relations Act 1967, where the function of this act is to promote and maintain industrial harmony and to provide for the regulation of the relationship between employer and employee. This act also serves in preventing and settling any dispute or conflict arising between employer and employee. Back to the case, it is about the dismissal of work against Abdul Malik bin Jaafar, which is referred as the claimant, by Kelab Rekreasi Tentera Udara, which is referred as the company. As we know, dismissal can be from many cases like major or minor misconduct, falsifying record, breach of contract, retrenchment, and many more. Thus, the case that been reviewed was the case of being dismissed due to unsatisfactory work performance. This case is referred under Section 20, Subsection 3 of IRA, where once receiving the notification of the Director General under Subsection 2, the Minister may, if he thinks fit, refer the representation to the court for an award. Therefore, in this case, the issue that need to determine by the court is whether the claimant has unsatisfactory work performance and whether the company's decision to dismiss the employment of the claimant was made with just cause or excuse.
Based on the case between the claimant and the company, we can see that the claimant was terminated due to his poor performance during performing his duties at Kelab Rekreasi Tentera Udara. Since poor performance is considered as a major problem to the company, so it is necessary for the company to take some disciplinary action or procedure before terminate the employment of the claimant. In this part, I'm going to talk and show all of you the situation of case before hearing or before enter into the industrial court. On 15 August 2017, the claimant was given a warning letter by the company. This is because the area of food premises that managed by the claimant is in unclean condition and directed to close for 2 days after inspection made by the Petaling District Health Department. In this situation, the claimant just be reminded by the company to perform its duties more efficiently. On 20 February 2018, the claimant was given a show cause letter because the food order that prepared by him did not follow the directed standard. After receiving a show cause letter by the company, the claimant replied to the letter, where he replied by giving answer and apologized and asking for an opportunity to improve his mistake. But unfortunately, the show cause letter was not accepted, where the company has issued a warning to the claimant because the answer on the show cause letter that given by the claimant unsatisfactory. In this situation, the claimant has been given a period for 3 months to improve all his mistakes and reprimand given by the company. Again, on 7 November 2018, the claimant was given a show cause letter due to his offence, where he provided food that did not meet the quality and taste according to the SOP that has been set by the company. On the same day, the claimant responded to the letter by apologizing to the company and he will be responsible for the incident. And again, the show cause letter was not accepted by the company, where the company has warned the claimant because he failed to provide unsatisfactory answer in the show cause letter. In this situation, the claimant has been reminded to monitor every meal that ordered by the customer. After giving several warnings by the company, the work performance of the claimant is still did not show good improvement. Therefore, on 9 November 2018, one formal interview was held by the captain of Kelab Rekreasi Tentera Udara on the claimant. In the interview, the claimant was given a final warning and a period for 3 months to improve all the weaknesses that have been reported before this. At the same time, the claimant also signed the interview letter, where in the letter, it is clearly informed that if he failed to comply every condition that has been set, then the company has the right to terminate the employment of the claimant immediately. Again, on 26 November 2018, the claimant has been given a final warning due to his mistake of failing to perform his duties properly. After a few months, the company has received complaint from the customer regarding the incompatible of the quality of the food ordered. We can see that this problem arises due to the negligence that committed by the claimant itself. After what was agreed in the formal interview that held earlier, on 2nd February 2019, the claimant has been given a letter of termination of employment. After following the decision in the GC meeting, report and complaint that received during the period 2017, 2018 and 2019, the letter of termination of employment against claimant was effective on 31 March 2019.
Okay, now I present the issue in the hearing. The hearing sessions was held on 14 February 2020 and 25 August 2020 is to determine the issue whether the claimant has unsatisfactory work performance and whether the company decision to dismiss the claimant was made just cause or excuse. In this regard, the chairman of the industrial courts needs to decide the issue arises whether the dismissal is valid or not. The issue would be further analysed whereby the evidence would be taken in this hearing session. In these hearing sessions, the evidence had been taken when the claimant agreed and signs the interview letter without any objections, where in the letter it is clearly informed that if he fails to comply with every condition that has been set, the company has the right to terminate the claimant service immediately. Next, the claimant has admitted to the representative of the company that it is his duty to inform the manager of FMB about the supply of raw material and agree after question by the representative of the company where he will be found guilty when the raw materials are insufficient. On top of that, the claimant testified and admitted regarding the issue on the lack of monitoring and inspections on the food orders from customer has been damaged. The claimant also admitted that the issue of shortage staff is not related at all with monitoring and inspections of food quality conditions that has been accountable to him. Other than that, the claimant disregarded the opportunity given instead of apologize only for the incident. As can be seen from the finding, the company had succeeded to prove on the unsatisfactory work performance that the claimant is guilty against his mistake. The court found that the claimant had exhibited unsatisfactory work performance as an assistant chef in KRTU kitchen, where he had failed to comply with every conditions that have been set by the company. That's all from me. Okay, now I will pass to the next presenter.
If the court finds that the claimant has been dismissed, then the court is required to determine whether such dismissal have been made with just cause or excuse. According to the law, the court has referred a few related cases to make a decision for this issue. One of the examples is the case between Wong Yun Hope and Syarikat Hong Leong Assurance Sdn Bhd and Anor Appeal. In this case, the issue is to determine whether the misconduct or irregularities complained of by the management as the ground of dismissal were in fact committed by the workmen, and if so, whether such ground constitute just cause or excuse for the dismissal. In the case of Abdul Malek and KRTU, after hearing the evidence presented by both sides, the claimant and the company, the court found that the company has successfully proved that the claimant has shown a poor quality of work as an assistant chef, where he was not be able and failed to perform his duty in monitoring and conducting a proper inspection which set by the company. In addition, the court also found that the company's action to terminate the employment of the claimant on the ground of poor performance has been made fairly. This is because the company has a justification for not being satisfied with the claimant's performance of work, although he has been given the opportunity for many times to improve the quality of his work. However, the claimant just ignored the opportunity given. Therefore, upon analysing the evidence and fact of the case in its entirety, the court is satisfied and do hereby find that the claimant's dismissal by the company was done with just cause or excuse.
Based on the issues in this case, what can we recommend? The claimant himself should focus in performing his duties. For example, he must always follow the SOP that has been set by the company, such as ensuring good quality in the process of food preparing. As stated in this case, the area of food premises in Kelab Rekreasi Tentera Udara was directed to close for 2 days. This is due to unclean condition, so the claimant should be aware about the work environment, especially in terms of cleanliness of kitchen equipment. Other than that, we recommend for company to provide adequate training to the claimant, such as training related to management affairs. By doing this, it can help the claimant to be more professional in handling each task given. As we can see in this case, all tasks related to kitchen management and food ordering are only managed by the claimant alone. So, to reduce the workload burden by the claimant, the company may hire a few number of employees to help the claimant in the kitchen. This can help the claimant in doing work more faster and complete his work according to the time period that has been set.
To sum up, the dismissal issue are governed by the Employment Act 1955 and the Industrial Relations Act 1967. This case is referred under Section 20, Subsection 3 of the Industrial Relations Act 1967. Despite the fact, the company has first told the claimant of the respect that he is failed to perform his job adequately, warning him and give him opportunity to improve his performance. But unfortunately, the claimant whose work did not meet the standard and does not do anything to improve his work. These cases are referred to the Minister of Human Resources and leave the court to make decision by giving the evidence and the fact. Also request to the court to review and re-examine the case back. Providentially, this case is clearly with the evidence that proved by the company. Make it the company wins this case. Therefore, the company actions in terminating the claimant service was done with just cause and excuse, and the claimant case is hereby dismissed. That's all from our group. Thank you.